So, hello and welcome to Vestralex free online community classes on law. This is your initiative for you, by you, and possible only through the generous contribution of time and effort of our seniors, guides, and mentors. Today, we have the opportunity of learning from yet another legal luminary, a stalwart of law from the Delhi circuit. But the introduction today, for a change, will not be read by me, but by Mr. Dhananjay Gupta, who is a lawyer from Delhi and practicing at Delhi High Court and various forums. So, Mr. Gupta, I request you to kindly introduce, sir.
Thank you, Mr. Keshav. Sri K.K. Manan is a senior advocate and a renowned criminal lawyer, widely respected in the Indian legal fraternity for his expertise, leadership, and dedication. He is a first-generation lawyer from an agricultural family background who has reached pinnacles of professionalism by sheer dedication, devotion, and unwavering commitment.
Sir is not audible. Sir is not audible.
Abhishek ji, thank you so much for that. Abhikle, let's continue right now. Maybe we can check the audio setting.
Over more than 4 decades, Shri Manan has handled high-profile criminal cases. From 1991 to 1993, he has served as a central government standing counsel at the Delhi High Court and also was a public prosecutor during this tenure in the Delhi High Court. He was conferred with a special status as a special prosecutor in the defamation case of the then Prime Minister Shri S.D. Dev, which speaks volumes about his professional aptitude. His legacy is marked by integrity, eloquence, and an exemplary commitment to the advancement of the legal community. Shri Manan has served as a chairman of the Bar Council of Delhi 3 times, from March 2007 to August 2008, again from August 2014 to July 2018, and was elected unopposed for his recent term starting December 2022. He has also been a member of the Bar Council of Delhi.
Mr. Gupta is not audible.
For 5 consecutive terms. Shri K.K. Manan.
Dhananjay, please continue. Abhishek ji, I'll just request, we can mute. I request everyone to kindly keep their mics on mute, please.
Shri K.K. Manan remained General Secretary of New Delhi Bar Association Patiala House Court 3 times and was also President of the New Delhi Bar Association Patiala House Court 3 times. Thank you, sir, for taking time out, for taking valuable time to guide us. We welcome sir and request him to kindly take over the class.
So,
thank you, brother.
Before sir officially handing it over, I request everyone to kindly please keep their mics on mute. I will also put, even though sir's introduction is available everywhere on the internet, but I will still again put the introduction for sir in the chat box also, so that anyone who has been able to miss it may kindly go through it again. So, very warm welcome, sir.
First of all, I would like to say thanks to all of you that you have given me an opportunity to introduce myself with the youngster, especially who loves me and giving me so much respect. For that purpose, I am grateful, indebted. Today's topic, that whatever I have learned a little bit in my life so far, I will share with you people that I started my practice from Patiala House. I used to say in Hindi, Patiala House is my Karam Bhumi. Whatever I am today, I am because of Patiala House, trial court. So, all over country, I used to go now in every high court, almost except 1 or 2 in the northeast. I have appeared in all the high courts. Before I start my career, I can say I'm from the village, son of a farmer, and my father was a farmer, though he was a sarpanch of the village. But at the same time, contribution to make me and to be here today, that is, I will say, my mother. My mother, when I was even 4th class, 3rd class, used to put rak, rak, that mitti, you can say soil, on that 1, 2, 3, A, B, C, D. She used to teach us. Anyway, I will come on the topic. You see, in a criminal trial case, one has to, whenever FIR registered, before that, almost every client to a lawyer approach the lawyer and hand over the copy of the FIR. If he does not hand over the copy of the FIR, then you now it was available with the Elmad earlier days, but now it is available on the net. You can take out the copy of the FIR. A good criminal practicing lawyer used to go through the FIR minutely, not once, even 10 times. You go through the FIR. Whenever you will read the FIR time and again, you will take out new point in that FIR to wriggled out from that FIR, whether for a bail, thereafter anticipatory bail or regular bail, whatever it is. But at the same time, when after the arrest, if a heinous crime like murder, robbery, cheating in a big way, or SC/ST Act, or number of other, economic offenses are there, where the bail usually not to be granted immediately, then the person has to be taken into custody. And if the person is in custody, then you have to move an application, first of all, before the London magistrate. Thereafter, the Sessions Court. If he doesn't grant, then you have to approach the Honorable High Court, Supreme Court. But in few cases, in few sections where the sections have been invoked and the false cases are there, then you can move an application for anticipatory bail. You can get the anticipatory bail if you make a good case before the London Additional Session Judge. It depends upon judge to judge. I will say frankly, I don't afraid to say this. Few judges are very, conservative to grant the bail, and but not all, but most of the judges, if you are able to make out the case, you will get the anticipatory bail. But as I said, that not in every case, like in Pota, Makoka, earlier it was Makoka, Tada, bails were not granted even years together. But now you see that POXO bail is not so easy, but when economic offenses and you know that ED etc. cases. But at the same time, now I will say that bails are not most important, especially in murder cases or in heinous crime cases. You have to tell your client, don't press for bail immediately. Whenever the stage will reach, we will move an application for a bail, but don't press us, don't unnecessarily harass us for grant of bail, because clients, the tendency is, let get the bail us, get the bail, get the bail. They don't concern. They are not worried about the trial. They don't afraid from the trial. They know it that once the bail has been granted, trial will take at least 10 years, 20 years, 15 years, and not less than 5, 10 years. So, in heinous crimes, we should tell the client frankly that don't harass and don't press us to move an application for bail. So, because in some time we move an application for a bail, sometime we used to disclose our defense in the bail application itself, which is very very I can damaging for the trial, because we should not disclose our defense in trial cases, in the trial court, or at the stage of bail. We have to take the defense at appropriate stage, that is especially during the cross examination. And we take the defense not only one way. We can take two, three, not lot of grounds are there to take the defense. Sometimes we can take the defense even of alibi. Alibi is very, very important, as well as is very, very difficult to prove it. And usually sometime, if you don't have any documentary evidence, if you don't have anything that you can't prove the alibi, so don't take it. There are number of other grounds, there are number of defenses you can take during the trial, but don't go in a hurry to take the defense, at least at the stage of a bail. Simply say, we have been falsely implicated, or I have been falsely implicated in this case, such and such enmity is there, or police has implicated me falsely in this case on the behest of such and such people, or with the connivance of such and such persons. But that is also, like I can say, golmol. In Hindi कहते हैं ना गोलमोल लो. So you can change your defense during the trial, when the case file will come before you people. But when the trial starts, first of all, if you are on bail, summons will give to the accused. Accused will approach you that I have received the summons, such and such is the date. You take the client and instruct the client to appear on that day positively, because in criminal trial, accused has to appear on each and every date. So instruct him to appear on that day before the court, and you will also go there and ask for the charge sheet, copy of the charge sheet from the trial court, and the trial court will give you the copies of the charge sheet, and you have to count the pages and the relying documents, and you should know from where you have to see whether the documents are complete or not. That I will tell you. In the charge sheet itself, charge sheet, list of witnesses, then list of documents. Then you have to see list of documents, as per the list of documents, whether all the documents have been supplied to you or not. One. Number two, the list of witnesses, whether they have given you the statements of all the witnesses or not, under section 161 CRPC, in POXO or a rape case or somewhere else, wherever the statement under section 164 CRPC earlier was recorded, whether it has been supplied to you or not. Even the court will give you the date that on the next day, please come prepared if the documents are complete or not. And then there are two types of cases before the trial court. Number one is trial by the magistrate and trial by the Honorable Sessions Court. If on the next date your copies are complete, the court will ask you, if the copies are complete, then court has to send the case to the Sessions Court. If magistrates travel by the magistrate, then he will keep it with himself and will say that on the next date we will arguments on charge. If charge you want to argue, if you don't want to argue, then okay, charge will be framed. If the charge will be framed before the trial court, thereafter evidence, witnesses will be examined. In the Sessions Court, on the first date, court will ask you whether the charge sheet, you have got the charge copy of the charge sheet, complete documents. Then they will also give you the date for a arguments on charge. Likewise, on the next date, again this trial court, Sessions Court will give you the next date, and charge will be framed. After framing the charge, then they will have to give the dates. Sometime, though it is written in the CRPC earlier, whatever the new, I don't remember the new name, but in the CRPC itself, in the Sessions case written, once the trial has been started, day to day it will be started. But by and large, every court doesn't do this now. Practice is not this. Earlier it was, before 80s, 70s, it was the practice that once the charge has been framed, and thereafter once the evidence starts, then continuously, first, second, third, fourth, whatever the dates, continuously they will record the evidence. And now They will give two dates on session trial. In one date in the magistrate court, give you 6 months date, 3 months, 4 months, sessions maximum 3 months dates for recording of the evidence. Once the evidence starts, then first of all, prosecutor has to examine the witness. Examination in chief. We used to say for that, examination in chief will be recorded, got it recorded, will get it recorded by the prosecutor. Then he will hand over the witness to you for the purpose of cross examination. Cross examination is a very, I can say the important point. In cross examination, I used to say one question will take you towards the heart if you will put a wrong question, or if then your client will be landed in the hard jail, I will say. And if diligently you are asking the questions to prepare the cross examination, and cross examination is an art. Good lawyer, before cross examination, go through the each and every document of the charge sheet, and you will find it sometime the DD entries. DD entries are very much beneficial for you people, for the defense. Go through all the uh, DD entries, crime report. In sessions cases, most of the cases, crime report is there. Crime team comes to the spot, so they prepare the crime team report. You please go through. Usually people don't go through crime report, they skip. Usually, I will not use the word usually, but I will say at least 90%, 99% lawyers don't read crime report. In crime report, you will get, at least I can say, 80% I got the acquittal from the crime report itself, because crime report is a document which is primarily at the spot. Immediately local police comes, thereafter the investigating officer takes the investigation. He used to call the crime team at the spot, and crime team comes. uh, Fingerprints, they used to lift the fingerprints, footprints, this that number of things they used to lift from the spot. For that purpose, crime report is very much important, which we usually overlook it. But I will suggest you, advise you not to overlook the crime report. Even you take out tomorrow any criminal trial, murder case, or any session trial, crime report would be there. You will get a lot of lacunas in the crime report and in the charge sheet. Even the investigating officer, crime team usually instruct the investigating officer, do this, do that, collect that evidence and place it on record, which the investigating officer doesn't do it. If he doesn't do it, you take the benefit of that lacunas or those lacunas, and for that purpose, crime report is most important in a criminal trial. So once, now I'm coming on the second point. Once you start cross examination, before that you have to read the statement of a witness under section 161 or his supplementary statements, not once, minimum 10 times. You go through the statements under section 161 and his supplementary statements, and for that purpose you see the statement on which date it has been recorded. If it has not been recorded immediately, doubt is there, the person, it means, was not present at the spot. It was introduced subsequently. He was not the eyewitness but made the eyewitness, because if he was the eyewitness, his statement would have been recorded there and then. But 99% the investigating agencies record their statement, whether they record the statement next day, but they put the date on the same date. But sometime documentary evidence is there, the person is at on the duty or somewhere else, so they can't put the same date, so they have to put the date on which they have recorded the statement of the witness. For that purpose also, delayed recording of delayed statement, like delay in FIR, likewise delayed statements are also beneficial for the accused. For that purpose you have to be very careful. For that purpose I am doing one case, murder case. I am doing it, I will not disclose it. In that case, incident was taken place on 28th, but in the morning 7 p.m., 7 a.m. But the statement, the FIR has been recorded in the evening 4:30 p.m. Meaning why the witness was not there, whose statement was recorded and whose statement the FIR was lodged. Then the other four witnesses are there, and their statements have been recorded on 30th, meaning 2 days delay is there. Meaning by that those people were not present at the spot, they have been introduced subsequently. One, and you have to see whether the witnesses are closely related. This is also one of the point, though the Honorable Supreme Court or various Honorable High Courts, our own Delhi High Court, said sometime, I mean, in every circumstance or every time, if the witnesses are relatives, close relatives, their evidence can't be discarded, but has to be read minutely, carefully. So the statements of the near and dear relatives, close relatives, are always has to be read by the court very diligently, carefully, and you have to take the benefit of that, and you have to bring their relations on a record. What was the relation? What is the relation of this that witness with the deceased or with the complainant? Other thing, if the delayed statements are there, you can put the question that you were not there because your statement was recorded on such and such date. And important question in that you have to ask the witness, incident was taken place on 28th. Were you available on 28th at the spot to the police? If he says yes, I was there, then uh, your problem will be solved. Meaning by police has not recorded the statement, then you can make the suggestion, no, you are wrong. You are not there. Your statement has been recorded on 30th, which was introduced later on the instance of the complainant. It means your presence is doubtful. Next, the witness, you can ask the witness in the cross examination number of questions, availability of other witnesses, if the place of incident is a thickly populated area, whether any independent witness was examined by the police or not, whether they were available at the spot. Sometime you must have heard and seen in the trial that there was a lot of people gathered at the spot. Lot of people means, if nobody was ready, at least somebody nearby or in the neighborhood must be there. They can't deny, they cannot say that we will not become the witness, because there is a section in the CRPC, if somebody has seen the incident, he cannot say no to become the eyewitness, because otherwise police can take the action against them, against that particular person. But usually they don't take, rather they don't make the witness like that person, because if that person is reluctant at the initial stage, tomorrow in the court he will be declared hostile. So they avoid to record his statement. And when the statement was that was being examined in the court or is being examined in the court, then you have to be very careful while his examination chief is being recorded. You have to see minutely his body language, whether he was tutored or not. Examination chief can be tutored by the prosecutor, by the NAB court, by the complainant, by the complainant's counsel, but cross examination cannot be tutored to anybody. For that purpose, you have to put the cross examination in a very diligently and carefully to that witness, that what type of questions you have to put it. You have to frame the questions. For that purpose, if four witnesses are there or two witnesses are there, you have to bring the contradictions in the test cross examination of those witnesses. It is very important. If material contradictions you will bring on the record during the trial, then you will, I can say, win the case. And if you can't, if you don't win the case in the trial court, 100% you will win the case in the high court. In the high court, you will get the benefit of all these things, because in the high court, uh, judges used to sit with a broad-minded, always armed with the latest law settled by the Honorable Supreme Court and various other Honorable High Court. So, sometimes you see that trial court is reluctant and sometimes afraid from the High Court giving the relief. So, I will say that at least if you have cross-examined the witness properly and carefully, diligently, then in the end you will be able to get him acquitted. Now, after examination of all the witnesses, then the accused will be examined under section 313 CRPC, earlier though CRPC, or 281 CRPC. 281 CRPC memorandum of, they will not put the questions, they will give the total memorandum. You will have to answer. Your accused has to answer that memorandum. Under section 313 CRPC, judge will give you question one by one. He will put the question, your client has to answer. There usually, by and large, judges used to give the statement of the accused to the lawyer. Please fill up this. Otherwise, sometimes few judges don't do that. They used to call the accused in the witness box and put the question one by one, and you make your client, your that accused, to be prepared for that purpose. He has to answer each and every question put by the court to the accused diligently, as well as whatever you have prepared the defense in the cross examination. He has to bring that defense in his statement under section 313 CRPC. When statement of accused was closed, then it is the right of the defense accused. Then he can examine his own witnesses if he has. If you want to produce any defense witness, if you have good defense by way of a documentary evidence, then you can put your client, that is the accused, in the witness box. That is section 314, I think. 314 hai. I think 314 hai. In that, you can put 314 or 350.
Accused SA 313.
And for that purpose, documentary evidence, you can get it exhibited through the accused, or if you don't want to get him examined, then you can bring the witness, defense witness, or the evidence that alibi you have taken it. Then you have to produce the witness with whom he was. If documentary evidence is there that you are on duty when this incident was taken place, at that time you were on duty and you were in your office. For that purpose, you have to see you see that the section that this witness will depose before the court. Okay, he was with me, he was on duty, he was in the office, likewise. Otherwise, if he was, you people, if the accused at the time of incident, he was in a marriage. I am doing one case in which they were shown that he was beating such and such person, but actually he was in Aligarh. He was in a marriage. We brought the marriage, that album, and a few other things, photographs, album, and the persons with whom he was standing there. Yes, he was not in Delhi at that time, he was in Aligarh. So likewise, you have to examine those witnesses, or in your defense, sometimes things are in the hands of other witness which have been framed against you. So he can be a best witness, defense witness for you. After defense witness, because I was telling you exactly that under section 315, you can examine your client also as defense witness. Now, after defense, then the arguments will start. That is also most important in the criminal trial. If you have to be a good criminal lawyer, then for arguments, you will again read the total file, total charge sheet. Total, you have to read it out from DD entries, crime report is there. Then you have to show, and sometimes the MLC, post-mortem report, are like in a murder case, and 307, or where is the quarrel or fight is taken place, then MLCs are very important. In a death case, in a murder case, post-mortem report is very important. You have to see the post-mortem report very minutely. You have to see that the weapon of offense which was used in the quarrel or in a murder case, whether that injury can be sustained with that weapon or not. Even in a, if somebody was shot, for that purpose you have to see whether it was a rifle, it was a revolver, it was a katta, desi katta. I mean, you will find that there are differences, lot of difference in all these weapons. So you have to minutely examine all these things in the MLC or in the post-mortem report. When you will examine, I forgot to tell you, when during the trial, doctors also come to prove the post-mortem report or the MLC. You have to very diligent to put the question before the doctor, because they are the expert. You are not the expert, medical expert, but they are the medical expert. You have to put a question very diligently. Like, I mean, if you will put a plausible defense, plausible question before the doctor, then question answer can come in your favor. If you will put the question, I mean, which is not relevant here and there, then he will explain each and everything, and he will explain the injuries also, which will be very difficult for you to wriggle out. For that purpose, you have to put questions to the doctor very intelligently, diligently. And other thing is that FSL reports also comes in the criminal trial cases. In the criminal trial, FSL report, in every case, you don't cross-examine the person who comes from the FSL. But sometime you have to put a question, because it's my little bit experience that whatever the investigating agencies say to the FSL, most of the cases, not all officers are not, I mean, bound by the opinion or bound by the investigating officer. They give the independent the reports of the FSL, but the investigating officer, usually they try to get the FSL report as per their choice with the connivance of the FSL office. For that purpose, you have to put the question to before those persons very like doctors, very diligently, intelligently, and usually don't cross-examine the FSL witness. Even otherwise, in the CRPC, it is there. I think section 290 something, in which the FSL 293 or 294 SCRPC, in which the FSL report is admissible. But Supreme Court said time and again, it is not admissible like this, and you can't say that it is 293. Yes, 293 CFS reports are admissible, but at the same time, uh, I will request you people that if no question is made out to put before the doctor or before the FSL witness, don't put until it is very, very necessary. Then I'm coming again on the point of the arguments on final arguments of the trial. For that purpose, as I was requesting you, telling you that you have to go through minutely the charge sheet, then all the testimonies of the witnesses. You have to find out what are the contradictions in between the witnesses. Whatever examination chief witness A says something else, witness B says something else, but this contradiction, this discrepancy should be material, not formal, not major. But major contradictions, if are there, you will get the benefit 100% and you will get the acquittal of your client 100%. But you have to bring the discrepancies uh, in the knowledge of the court. You have to take out, make a chart. PW1 says something on this point, and PW2 says on the same point something else. And whatever your defense is, you have to bring it by way of suggestions. I forgotten to tell you all in this also. You have to bring your defense in the cross examination, and you have to give the suggestions to the witness. Whatever he has said in the examination chief, please give the suggestion that on such and such point you are telling lie, on such and such you are telling lie, it is wrong to suggest you are telling such and such. All the major points he has given you, given against you in the examination chief, you have to put the suggestions and make it wrong, false in the suggestions in the cross examination. I forgotten it. I may be pardoned for this purpose. And it's a very important thing that suggestions are very necessary. If you don't give any suggestion to the witness while cross examine the witness, if you don't put your own case before the investigating agency officer as well as before the eyewitness, then it will be a Himalayan blunder on our part. So I'm coming again on the arguments. So final arguments is so important. That was the last pedal, last chance for your uh, client, where he has to sometime, even today, these days, and for the last about many years, more than 25, 30 years, people used to engage me only for arguments. People used to engage me only for the purpose of cross examination or for arguments. And for that purpose, we have to prepare the case very, very intelligently and diligently. And in cross examination, whatever we have brought it, we have to hit that. Okay, such and such things have come on the record. So kindly note down, Judge Sahab, these are the points where this witness told lie, false, frivolous, and here is the proof of that testimony. Because PW1 says something, PW2 says something else, and PW3 totally contrary to both of PW1 and PW2. All these things, contradictions, you have to bring it on record, but contradictions and the suggestions, and you have to cross examine. I'm coming again, I left another point. You have to study the latest law of the land, what the Honorable Supreme Court said on such and such point, on which ground the accused was acquitted by the Honorable Supreme Court, convicted by the trial court, upheld by the Honorable High Court, but acquitted by the Honorable Supreme Court, on which point he has been acquitted. Likewise, you have to bring that in the cross examination on a record. You put the suggestion or you bring the things or that type of law on a record during the cross examination itself. sometime you see the law comes on a medical, sometime of CFSL, sometime law comes on a weapon of offense, sometime law comes on a contradiction, material contradictions, sometime law comes on a non-examination of a witnesses, that material witness has not been examined, hence it is fatal to the prosecution. Sometimes the investigating officer, by and large now, judgments are there. If the investigating officer has not been examined, it will not make a much difference. But court usually of the view it's a formal witness, but I'm not of this view that sometime, moreover I can say 90% interested witnesses and connive with the the investigating officer, automatically he has to build up the case as per the choice of the complainant. So investigating officer is equally very important, very important. So all these things we have to take care, and we have to uh, take it uh, intelligently while cross examine, while arguing the case. So all these things in the trial court, and so far as practice in the Supreme Court or the High Court on the criminal side, it's very easy, very easy. High Court, toughest is the trial court. Easy 50% is the High Court, 100% I can say 99% easy in the Honorable Supreme Court, because mostly judges comes prepared, gone through the file. You have to hit and point out the major point. They don't give much time, but now the Honorable Supreme Court judges also giving lot of time to the defense, also to the arguing counsel. In earlier days, I think more than half minute is more than enough. They used to come and dismiss. Now the judges are giving the time in criminal trial and properly. At the same time, in the Honorable High Court also, judges give you the proper time to build your case, to rebut the case of the prosecution, and to demolish the case of the prosecution. For that purpose, you have to study properly whatever the case you have in your mind, and supported with the judgments. Thank you. That's all, whatever little knowledge I have.
So, so how do I say? It was just wonderful. The chat box also became very lonely because everything was falling. So that was falling from you. It was just encompassing the entire sphere. So, first of all, I thank you so much for taking us so diligently through the entire trial process. Sir, one fundamental question that I will want to ask you at the initial stage
Sure.
is, so I request everyone to also kindly put your question in the chat box or raise your hands so that we can take your questions one by one. So in the meanwhile, I'll give a leading question, sir. That what is the process or how do you suggest in your vision, sir, that a person goes about where the police refrains from registering an FIR?
Could not follow you. Frame the question again.
So where the police refrains from registering the FIR, or let's assume that where they file a closure report in a matter.
Yes.
So
In a closure report, you have to, before accepting the closure report by the magistrate give the notice to the complainant. You can file the protest petition in that situation, and closure report filed by the investigating officer, usually 99.9, the magistrate doesn't accept it straightway. Most of the cases they will return it with the directions, investigate further. And if the magistrate is of the view to accept the closure report, for that purpose it is the bounden duty of the magistrate to call upon the complainant, give the notice to the complainant. If the complainant is not satisfied, then he will give the time to the complainant to file the protest petition by way of a complaint case. So he can file the protest petition in that situation. And the another thing, I think your question was where the investigating officer is, I mean, they don't get the case registered. I think it is also a question, your question. Then, if they
Balancing
don't
the
register the case, then alternative before us is, number one is that whatever the complaint you have given to the SHO, we have to give those complaint copy of those complaints to the higher authorities, ACP, DCP, Joint CP, and CP, High Home Minister, etc. Then you can go under section 156 subsection 3 of the CRPC earlier. Latest I do not remember. And under latest, even we used to compare it. Now even daily we compare it with the new and the old one. So if they don't get the case registered, then you have to go and file the complaint case under section 200 red with, or you can file an application along with the complaint under section 200 under section 156 subsection 3 of the CRPC, on which the magistrate can direct the investigating agency to register the case. However, before that, he used to call the status report from the police station, that why you have not registered the case, please submit your status report. They usually submit the report that it's a civil case, this and that. But because they are reluctant to register the case, because they don't want to make the heavy police station with the heavy load of FIRs, because it is also goes that if lot of FIRs are there in the police station, it means that crime is there in their police station. So they are reluctant to register the case. For that purpose, you have to knock the door of the learned magistrate. Magistrate can pass the order after seeing the status report and your arguments. Thereafter he can say yes, it is a prima facie case is made out, or register the case. He can direct the SHO of the police station or the crime branch or whatever the EOW. And if he also of the view that yes, all the evidence is with you, no need to get the case registered, so you can lead the evidence under section 200 CRPC in a complaint case.
Thank you, sir. Thank you. So there's a question from Advocate Antara Jain. Antara ji, you want to ask your question?
Hello, sir. Good evening.
Good evening.
Sir, it is an absolute pleasure to witness you speaking about the most crucial aspect of a criminal lawyer's life, that is the trial and how to go about it. So I'm privileged. Sir, my question is to you. If you could speak a little more about discrediting an eyewitness, how to go about it. Thank you, sir.
I said at the outset, while I was requesting and telling you people how to demolish the case of the eyewitness, you have to thoroughly study the statement under section 161 CRPC, and you have to bring the latest law laid down by the Honorable Supreme Court or the various Honorable High Court. You have to study the latest law. If you know the latest law of the land, or basic law of that particular section in which you are being tried in the court, then you have to put the question and you have to frame the questions in that way that the witness should be compelled to answer your all questions in a way that he will give you the way to go out of that case. It is up to you how to frame the question. As I said, the cross examination is an art. And even I skipped one more thing. Once you gain that you have put three or four questions and your purpose is solved, that then you leave that angle, you leave that line of cross examination there, and then you take another line and you don't bring that witness on the same old line, because if he realized that he has committed a mistake by giving such and such answer, then he will try to come on that also. But don't allow him to come on that line again. Put him on another line, take the cross examination on a different line, so whatever the questions answer have come which are in your favor, so it should not be rectified by the witness. Today I was cross examined one investigating officer in a POXO case today in Saket. Usually, I don't accept now the trials, but sometime good cases where really, if I think that I should also accept this case. So, a POXO case, I was cross-examined this investigating officer. His eyes were, I mean, he was sweating. He was sweating. Sweating, why? Because he did not go through the file. He did not know what he has made up the case. So he was already examined, I think 1 year back. So he came only for cross examination and forgotten the chief. So it is up to you. So as I said, that you go through thoroughly, that how to extract the truth, how to extract the points which you want in your case in the favor of the accused. Hope that you followed me now.
Sir, much obliged, sir. Thank you so much.
Thank
Thank
you.
you. Thank you, sir. So your
Sir, this is Advocate Abhishek Singh from Bombay High Court.
Abhishek ji, please, sir. So he's from Bombay. He's a
Sir, we very well explained the aspect of the discrediting the eyewitness. Sir, my query was that when the police does not lodge an FIR in particular case, and when we take that particular matter before the magistrate uh, under section 200, so at that time,
Read with
can we?
156 subsection 3
Yes,
CRPC.
yes. But the party on behalf of the party as an advocate, I don't want either 156.3 nor I want 202. So can I ask magistrate directly to issue a summons to the accused and go on
No,
with the trial?
no. He can't. He can't. If he will
Because
go,
because
if he will,
I had personally experienced one of the case in which the transaction was of around 28 to 30 lakhs rupees, and the complainant's advocate filed the complaint before the magistrate, and the magistrate directly issued the summons to the accused, and
that
the
was
sections
wrong.
were
You can go in the Honorable High Court and get it quashed. Can't.
420 sections.
He cannot do like this. He will without if under
even
section
even
200,
even
under
even I
section
was
200 he has entertained the complaint. You go through under section 200 to 202, 204. Then he has to examine the witnesses. Should I निकालना 204 कितना है? Then he has to examine the complainant first. After examining the complainant, of course, he can, without examining other witnesses. If he is satisfied that whatever the complainant has said, you see, under section 200, examination of the complainant. Without examination of the complainant, he cannot summon the accused straightway and issue a process under section 204 CRPC. Process तभी होगा, sorry, process in that situation the state way cannot be. Section 201 procedure by magistrate not competent to take cognizance of the case. Another thing, cognizable, non-cognizable, warrant trial, session trial, number of things are there. If 200 filed, 156 has not been followed, state way entertaining the 200 and without examination of complainant, he cannot issue the summons under section 204 CRPC. State way, it's a wrong
in
order.
that
You can challenge it before Honorable High Court.
in that particular matter, when I read the initial first order of that particular matter, in that matter only, it was stated in the order itself that complainant wished to go on with the trial directly as he made out the prima facie case based on the documentary evidence. So he
But he has to
neither.
examine
Yes,
under section
he had
200.
examined. He had examined after examination of the complainant. He neither
You
issued a
see,
156.3 order for asking for an
no.
investigation.
It's a
He neither
mandatory.
issued
It,
he
it just
neither he nor issued a 202 order of inquiry. He
just a minute.
directly straightway proceeded with the matter in the
Just a minute.
summons warrant tribal case.
Just a minute. You go through
Yes,
section 200 first.
yes, sir.
As I
Examination of
said, if he
complainant.
has committed this mistake by the judge, by the magistrate, the Honorable
Yes,
Magistrate's order can be challenged before the Honorable High Court. It will quest. Because you kindly
correct.
see, examination of the complainant is a mandatory. How it is a mandatory? I am reading the section 200. A magistrate taking cognizance of an offense on complaint shall examine. Word is shall shall
Shall
examine upon oath the complainant and the witness present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate, provided that when the complaint is made in writing, magistrate need not examine the complainant and the witness. If the public prosecutor, if the public servant, if the public servant, like custom cases, FERA cases, in that the witness, there was no need. The another is, if the magistrate makes over the case for inquiry or trial to another magistrate under section 192. Provided further that if the magistrate makes over the case to another magistrate under section 192 after examining the complainant. So it can't be, because if the public servant is filing the complaint like customs cases, FERA cases, ED cases, then the complainant is no need to examine the complainant. But otherwise, under section 200 CRPC, complaint is filed and complainant has to examine, it's a mandatory.
Thank you, sir. Thank you so much. Abhishek ji, rest I will put you across to sir, and I request you to kindly consult sir officially. So if you have a proper query, it would be really wonderful in that respect. And so
Many top lawyers are there in Bombay. Very top lawyers, good lawyers.
सर
Are
जी, मैं भी कुछ
strong
बोलना हूँ, प्लीज परमिट मी।
sir, please, आप पूछिए।
सर जी, लगभग 20-25 साल पहले की बात है। पटियाला हाउस कोर्ट में यू आर द टॉप लॉयर एंड आई हैड बीन एन अक्यूज इन सम केसेस एंड आई हैड
मैं तो नहीं था कंप्लेनेंट का वकील आपके खिलाफ।
जी सर, आप नहीं थे
ठीक है।
परंतु सर, मैंने आपको कुछ कोर्ट्स में बहस करते हुए देखा।
अच्छा।
और मैंने ये पाया कि जो सेशन जजेस और जो मजिस्ट्रेट्स हैं, वो आपकी बात को बहुत ध्यान से सुनते थे।
अच्छा।
और मैंने कई केसों में ये भी सुना और मैंने पाया भी कि बहुत सीरियस मैटर्स में भी आपने एक्विटल करवाया है। परंतु सर एक
भी हुए हैं, सजा भी हुए हैं,
जो वो दूसरी बात है। हाँ, परंतु कई बहुत सीरियस केसों में भी एक्विटल करवाए हैं आपने। परंतु सर, जो मैं समस्या आपसे कहने जा रहा हूँ कि जैसे आप जैसे जो बहुत टॉप मोस्ट लॉयर्स हैं, उनकी तो बातें जजेस और मजिस्ट्रेट बहुत ध्यान से सुनते हैं, परंतु जो यंग लॉयर्स हैं या जो बहुत वेल नोन लॉयर नहीं हैं, उनकी बातें वो मजिस्ट्रेट्स भी ध्यान से नहीं सुनते सर। और कई बार तो मैंने देखा कि वो उनको सुनते भी नहीं हैं। और कई ऐसे केसेस में जो कि बिल्कुल प्योर एक्विटल के केस बनते थे, बहुत सिंपल, उसमें भी उनको सजा कर देते थे। तो सर, इसमें मजिस्ट्रेट्स और सेशन जजेस को खासतौर से ट्रायल कोर्ट्स में, जैसे आपने भी बताया है कि वहां ज्यादा मेहनत करनी पड़ती है एडवोकेट्स को भी, कि सर वहां जजेस और मजिस्ट्रेट्स को कैसे डील किया जाए कि वो जो सिंपल लॉयर्स हैं उनकी बातें भी उसी ध्यान से सुने जैसे आपकी बातें ध्यान से सुनते थे।
नहीं, मेरी बात भी सुनते होंगे। मैं भी यंग था कभी, मैं अभी थोड़े सफेद बाल हो रहे हैं, मैं भी यंग ही आया था वहां पे। 1980 में मैंने प्रैक्टिस स्टार्ट करी थी
जी।
और मेरे ख्याल मेरी गाड़ी 82 में स्टार्ट हो गई थी, अच्छी गाड़ी रेस पकड़ ली थी। मेरे को तो जजेस ने जैसे नाम ले रहे थे, जे मलिक साहब थे वहां पे, मजिस्ट्रेट थे, फिर हमारे ACMM भी रहे हैं, CMM भी रहे हैं। ACMM थे, CMM तो 30,000 ही होते थे। और इन जजेस में यंग था, मुझे इन जजेस ने सब ने बड़ा बैकअप किया है। मैं यंग था, बहुत छोटा सा, 2-3 साल की स्टैंडिंग थी। ऐसा नहीं है, बाय एंड लार्ज गुड जजेस आर बैकअप, एनकरेज यंग लॉयर्स एंड मोर ओवर। मैं एक ही बात कहूंगा, यंग लॉयर्स को भी मेहनत भी तो करनी होती है ना, मेहनत करके नहीं काफी लोग जाते हैं। आजकल तो ये ट्रेंड है और बच्चों को गाड़ी देकर ही भेजते हैं माँ बाप। अब हो भी गई हैं, उस समय की बात और थी, अब की बात और है। लेकिन मेहनत यंगस्टर को भी करनी चाहिए। बाय एंड लार्ज जजेस मैजिस्ट्रेट्स नए लड़के को, जो नया यंगस्टर आता है लॉयर, उसको इनकरेज तो करते हैं। लेकिन कई बार केस ही ऐसा होता है, यंग लॉयर है पर केस बहुत मतलब हीनियस होता है, तो अगर वो नहीं कोई ऐसी चीज रिकॉर्ड पे ला पाया तो फिर उनको सजा तो करनी पड़ेगी ना। अगर रिकॉर्ड पे नहीं ला पाया, जैसे मैं कह रहा था,
जी
तो
सर।
फिर तो उनको भी वैसे नहीं ना छोड़ देंगे कि भाई यंग है ये, तो यंग लॉयर के चक्कर में मुलजिम को थोड़ी नहीं छोड़ देंगे अगर उसने कोई क्राइम
जी
किया है और प्रूव
जी
नहीं
सर।
कर पाए कि मैंने नहीं किया, मैं
जी
इनोसेंट हूँ।
जी सर, 40 मिनट में सर
राइटली
आपने
सेड सर, राइटली सेड।
क्रिमिनल प्रोसीजर को समझा दिया है कि मेरे जैसा जो LLB नहीं है वो व्यक्ति भी समझ गया कि कंप्लीट प्रोसीजर कैसे होता है CRPC का। थैंक यू वेरी मच सर, वेरी ग्रेटफुल।
थैंक यू सर, थैंक यू सर।
सर थैंक यू सो
थैंक्स
मच।
कहूंगा कि आपने मुझे शुरू से देखा हुआ पटियाला हाउस में।
यस सर, यस सर,
मेरी तो
यस सर।
जन्म, मेरी कर्म भूमि है वो।
यस सर, यू
अरे
आर द लीडिंग लॉयर सर। लोग आपके
सर
बारे में बहुत बातें करते थे जी, हर कोई चाहता था कि आपको एंगेज कर ले, बट इट वाज वेरी डिफिकल्ट फॉर एवरीबॉडी टू अप्रोच यू।
मैं अपने जूनियर्स को कई बार बताता हूँ कि मैं कभी खाना भी नहीं खा पाता था। मेरी
जी
गली
सर।
भरी होती थी, मेरे पास 40 42 केसेस होते थे डेली के।
जी सर।
वो क्रॉस में ही मेरा टाइम निकलता था और मैं आज भी ये कहते हो ना, नतमस्तक हूँ अपने सभी जजेस के, मजिस्ट्रेट, एडिशनल सेशन जज, हमारी मिसेस दुग्गल थी, आज बीबी बंसल साहब थे, बाद में हाई कोर्ट जज बने, आज उनकी बेटी हाई कोर्ट जज है, नीना कृष्णा बंसल। ये
जी सर।
ऐसे ऐसे जजेस थे
जी
और
सर।
जिन्होंने मैंने बहुत कुछ सीखा है, बहुत कुछ मुझे उन्होंने इनकरेज किया है। मैं जो भी आज यहाँ तक हूँ, अपनी बार, अपने यंगस्टर लॉयर्स की वजह से हूँ, क्लाइंट्स की वजह से हूँ, और उतना ही अहम रोल मेरे जजेस का भी था मुझे यहाँ तक लाने में।
मैं सर एक आखिरी बात और कहना चाहूंगा। हमें ये भी पता लगा सर कि 2 बार आपको हाई कोर्ट में
Sir, one more thing
जाने
is
का
there
ऑफर मिला,
at present, the
तो आपने क्यों
agitation
नहीं
is
किया?
going on in the Delhi against the notification issued by the LG regarding with the trial, and they have proposed an idea to examine the IO through VC sitting in the police
Not
station,
only IO, the police officials. It's a
police
very,
official, police official.
it is
So
not a
kindly
good.
throw some light, kindly show some light
You
that
see
how
that
that notification is totally against the
yes,
administration of justice.
it is my. I have all respect for the honorable Home Minister. I have all respect for the Lieutenant Governor, but at the same time, Lieutenant Governor has followed the directions of the honorable Home Minister, and it is against the criminal jurisprudence. Not only it will damage the profession, but it will damage the, I will say, the defense of the accused persons. Criminal trial, criminal law, it will be derailed. And how you will cross examine, how you can exhibit the documents by sitting in the police station, and even 99% investigating officers comes in the court on the same day, same time. They used to go through the case diary, they used to see all the documents, only then they come in the witness box. And even in the police station they will read it out on one side in the of this case diary, and they will I mean give the examination chief as it is. It is not possible. It is against the, in fact, criminal jurisprudence. It is against the litigants. इतना lawyers पे असर नहीं है इसका. It is no, I mean, make any difference on the lawyers. We are
It
fighting,
is harm,
whatever the lawyers
it
are
is
fighting,
harmful
it is
for,
fighting for the litigants. This is the one cause where the lawyers are really fighting for the cause of the litigants and the public at large.
So, with your permission, can I ask one question?
Sir,
So just before anything else, sir, so there are a lot of questions. So the time that we had requested of you, that is over. So now I requested absolutely up to you. As for whatever number of questions you think fit, we will take.
Please, sir.
whatever the question you put, no problem.
So,
Please,
my
please.
question is, sir,
I'm happy that at least I have not appeared for IS, IPS, etc. Somebody you are putting the question, so I'm able to answer today.
so my question is, in a complaint case was made against a police official, and in which the court seeks a report under 202 from the police officials against their own officers. So, is it not contradictory that the presumption is that the police officials will not record or not give a finding against their own officers, and based on that, the primary this judgment based on the Please, sir.
Two things are there.
Please,
If
sir.
we make a complaint,
Hmm.
even there was a one case today against the ACP, SHO, and the investigating officer, Saket Police Station. Judge was on leave. The ACGM was on leave. Number one is, if the police official is doing something on duty, then sanction has to be required, has to be taken from the department. Number two, if he does anything on duty which does not come under the ambit of his duty,
Yes, sir.
going far away from that duty, then there is no need for any sanction. Then the state will go in the police station. First, you make a complaint in the same police station, or you can change EOW, crime branch, special cell, somewhere else against those, and higher authorities as well. You have to make the complaint before filing the 200 and 156 subsection 3. You have to make the complaints to the higher authorities as well. It is mandatory. And if the same police station against the same SHO, no, you have to change the investigating agency. If they will, it is up to the judge whether he is asking or she is asking from the same police station, or if you have made the another investigating agency, crime branch. So then crime branch has to file the status report, but the magistrate has to call for the status report.
So,
And they
sir.
cannot go out of that documentary evidence. If you have the cogent evidence with you, they cannot, digest, or, they will swallow that evidence. No, they
Well,
can't.
the interesting part in my case was that there is a GD entry which
Sir,
says,
what could be the outcomes of the
if may I let me
report
complete
of
first,
the
please.
police?
If you,
Report of the police when they
if my
come after the
if my
completing
voice is
their
audible to you,
inquiry and
समझ नहीं पा रहा
investigation
हूँ,
and
दो दो
everything.
दो 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 बोल रहे हो, किसका क्वेश्चन लूं?
please, sir. Thank you, Abhi, for considering my words. In my case, the interesting part is that when status report was called, GD entry was filed, wherein GD entry they say that a complaint was made to a police of in a thana that there is
Such and such police
such
station
and
में
such and
complaint
such,
दिया.
and Patwari was appointed, and based on that, Patwari went to the Chowki, and Chowki they came with officers. But on record, there is no complaint which is made to so and so authority. Thereafter, there is no order of Patwari or any sort of recording that based on this which is okay. Now the question is, the court is not taking into consideration, and the 202 report, the report that has been called from the police for postponement in terms some sort of clarifications required by the magistrate. So they call generally under 202. In that case, it has been remanded to
उनकी
the
voice ही
same
नहीं आ
ACP.
रही है.
You see that the court has to take into consideration each and everything. They cannot take away. If such things are not there and they have fabricated something, then they will be liable to be prosecuted for perjury.
Yes.
You have to bring the case in the parameter of the perjury then.
Yes.
Tell them that here is a case and move an application for a perjury. Here is a case, perjury is made out against them, initiate the proceedings for perjury.
Please. Thank you, sir. Thank you for addressing my question, sir.
Right, sir?
So,
Sir, may
yes,
I
sir,
ask one question?
there are a lot of questions, and sir, it's just a blessing that, how do I say, sir, it's just everyone is intrigued. So, lots of questions. Just, I think one from Ashok sir and one from Madhvi ma'am, and so that will be the last question that we will raise. But sir, we'll request that we have the opportunity of sir, this conversation with you and to continue this learning with you in the future also, sir. So, Ashok sir, please go ahead.
Thanks, sir. Thanks a lot. We are very grateful to hear this session. Actually, one question. What is the difference between final report and charge sheet? And in some case, they file charge sheet as well as final report. So,
As well as no.
because
Either
yes,
final report or charge sheet. Charge sheet will be filed where the case is made out, proper thorough inquiry investigation, and when it depends upon magistrate trial, warrant trial, session trial 90 days, magistrate trial 60 days, if the accused is in custody. If he is not in custody, either in sessions case or a magistrate court, then magistrate has that investigating officer has a lot of time to investigate the matter. After thorough investigation, collecting the material on record which is sufficient to prosecute a person, in that situation charge sheet will be filed. And if after in thorough investigation and collecting all evidence by the investigating officer, he comes at the conclusion that no case is made out, and he will file the charge sheet. He will file the final report, that is cancellation report. Then for that purpose, as I said, the magistrate will give the opportunity to the complainant, and he complainant can file. If he is agitated, he is not satisfied with the investigation, then he can file the protest petition.
Thank you. Thank you so much. Thanks.
So, Madhvi ma'am, just one final last question.
Yes, sir. Good evening, sir. Today's class was very informative. Thank you very much. And my question is, there are two parallel cases, sir. In two parallel cases involving the same eyewitnesses, and if the witness has already been examined and cross-examined in one case, can the chief examination recorded therein be relied upon in the second case to avoid recalling the witness?
Could not follow.
दो सेम केसेस कैसे चल सकते हैं?
Could not follow. If the witness has already been examined and cross-examined,
Yeah, in one of the cases, sir. And there is another case which is a parallel case. I mean, the same eyewitness. So can we submit the cross-examination
no. Then he has to examine and cross-examine and examine in the another case differently.
differently, even though if it's
Yes,
the
that in
same
the
content?
earlier case, examination chief and cross examination will
Okay.
not be only filed, but
Okay.
for contradictions
Mhm.
after examination and cross examination, you
Mhm.
can take the certificate copy of the earlier case. If there are contradiction and the material contradiction on the same point, then you can file the certificate copy before the that learned trial court. Then here he is speaking something else, and he has already spoken something else in same issue and same point. So you can take the benefit of that. But in the second case, he has to be examined fresh.
Re-examined again. Okay. So one more last question, sir. If the IO omits relevant IPC sections in the charge sheet, despite there are sufficient evidences, under which provision can the informant move the trial court to seek addition of appropriate sections?
You see that section, whatever the sections are being invoked by the investigating officer, doesn't matter.
Okay.
Though they should invoke the proper sections, relevant sections, but if they don't, even at the stage of charge before the learned magistrate or the learned honorable sessions court, then they will frame the proper and the section. They will invoke the sections which are premises made out.
Okay. Thank you very much, sir, for your time. Yeah.
Thank you.
Thank you so much, ma'am. Ma'am, sir, thank you so much.
Thank you,
People-
brother. Thank you.
How do I say, it's been a privilege, sir, to have this occasion. I think it's a very good refresher for anyone who's currently practicing, and very good.
Keshav, your voice is not audible.
अभिषेक जी, अब ना कुछ करेंगे हम पक्का सर. ये आपसे रिक्वेस्ट भी है कि सर इस टाइप से with this humble initiative that we do not have a lot of resources, तो जो हमारे पास इक्विपमेंट है उससे हम काम चला रहे हैं कि आवाज भी हमारी सर कई बार शायद ठीक तरीके से नहीं जा पाती है. अभिषेक जी, थैंक यू सो मच फॉर पॉइंटिंग इट आउट. बट मनन सर, अब यहाँ पर सर, यहाँ पर एडवोकेट के साथ साथ लीडर वाली रिक्वेस्ट भी है आपसे दैट सम सर कुछ दया दृष्टि, कृपा दृष्टि और गाइडेंस इस रिस्पेक्ट पे भी सर आप प्लीज बनाइएगा आपका. And sir, how do I say deepest gratitude to you, sir, for addressing all of our questions. And sir, there are so much more सब जो आपसे और चीजें पूछना चाहते हैं. But I'll only humbly request that you give us more opportunities.
Yes, of course I will. Definitely. Whenever you will ask me, I will come. No problem.
So no doubt, sir, दो चीजों का तो sir confirm है. One is with respect to.
If you have to buy the instruments, you also tell me. I will not elaborate much.
Ladies, I'm just kidding, sir, but that is how do I say, that is the blessing that we have at Delhi Bar, and I pray that everyone across the country gets to learn from your wisdom.
No, if I can do something for the youngster, no, problem for me. And if you require the proper infrastructure, I will, whatever you will ask, direct me, I will abide by that. No problem.
So it's very, very kind of you, sir. No, sir, I did not mean to trouble you like that. I was just wanting to be in lighter vein, sir. I wanted to be like that. But Abhishek ji, sir, he's been joining from Bombay. He's a very nice friend of ours. He's been one of my seniors also. He's helped me learn in Bombay as well. So gratitude to you, sir, also. And sir, how do I say, Manan, sir? Thank you so much to you once again. And
Thank
sir,
you.
we pray that we can keep on learning from you, sir. Gratitude.
Thank you. Thank you.
Take permission to end
I am
today's class.
still learning. I am still student.
And so there are lots of students here, lots of questions in the chat box, sir, which have gone unanswered. So I pray that
Next time they should be ready, and next time I
Thank
will.
you so much, sir.
Thank you.
Thank you so much, sir.
May I
Thank you.
take leave now?
Yes, sir. Sir, deepest gratitude
Thank
to
you so much, sir.
Thank you. Thank you, brother.
Thank you, sir. So thank you so much to everyone who has joined. Thank you so much for your kind questions and your support. Now, I only humbly request you to, since we are a very humble initiative and obviously in lighter vein, we sometimes drift off also. So my request to you is that please share your support. It is your support which keeps us going. Share it with your friends. From now till November, we will be doing one class on Wednesday and one on Saturday. So please, guys, volunteer also. That is most appreciated. Suggest your seniors whom you would want to learn something specific from. Help us, our seniors. I request you. I'm grateful, first of all, for all of your support, but I also request for your guidance and blessings continuously. And with that, I seek your permission to end today's class. And thank you so much for being such a wonderful participation today. And how do I say, just one final word of apology to everyone whose questions we have not been able to take up today. I request you to please share them in the chat box and we'll try to see how we can address all of those. So gratitude. Please join the Vestralex, obviously register and join the WhatsApp group also. So you will get some more information over there and your questions you can always discuss over there. So thank you so much and